Senator Klobuchar.
Thank you very much, Mr. Chairman.
I'm sorry, what did you call me?
I called you Mr. Chairman.
Well, thank you.
We're all calling you that right now because you are
Blumenthal
you
wouldn't
are
call me
holding the
chairman.
gavel,
I
sir.
never called him Mr. Chairman.
All right, Mr. Meredith, as Chief Deputy Counsel to the Governor of Kentucky, you defended, as my colleagues have discussed, you defended a law that imposed severe and medically unnecessary licensing regulations on clinics. That law would have had the effect of closing what was at the time the last remaining abortion clinic in Kentucky. You argued that the impact of closing Kentucky's last abortion clinic would be essentially none for women. Why did you argue that closing the clinic would not have an impact on the women of Kentucky?
Senator, my recollection of that argument is that, of course, now we are under the regime governed by the Dobbs case, but at the time we were under the Roe and Casey regime. And my recollection of that argument was that Casey, I believe, had said it's not an undue burden to have to travel up to 150 miles to obtain an abortion. And my recollection is that the evidence in the record showed that no one or almost no one would have to travel more than 150 miles to obtain an abortion should that clinic close, because Kentucky's geography is such that all of the population lives within 150 miles of facilities in other states, Senator.
Is it true that the closure at the time would have required women to leave the state and travel up to the 150 miles if they needed health care?
I think that's right, but Senator, one thing to keep in mind is the unique geography of Kentucky is such that many parts of Kentucky are much closer to facilities in other states than to that one facility in Louisville. So, for instance, if you lived in southern Kentucky, you might be closer to Nashville or Knoxville than to Louisville. Or so it was that was the nature of that argument, Senator.
Last month was the 60th anniversary of Griswold, which established the right to contraception. In the Dobbs case, the Supreme Court clarified that its opinion does not threaten Griswold. They said nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. If confirmed, will you commit to adhering to the precedent established by Griswold and upholding the right to contraception?
Senator, I can commit to you that I will follow and faithfully apply all binding precedents of the United States Supreme Court.
Along those lines, Mr. Mercer, Chief Justice John Roberts wrote in his most recent end-of-year report that disregarding federal court rulings is, quote, dangerous, end quote, and, quote, must be soundly rejected, end quote. Do you agree with Chief Justice Roberts that any suggestion of disregarding a court's ruling must be soundly rejected?
Senator, I certainly have always advised clients to comply with court orders, and I believe that is an essential feature. There, I believe, are extremely rare circumstances in which there may be a basis to challenge the existence of a court order. But again, throughout the entirety of my career, and if I have the honor of being confirmed, it will be my expectation that any party subject to an order that I issue would follow it.
Okay, but I think he was talking about not people appealing court rulings through the regular course. He said disregarding court rulings. And do you agree with him that this should be soundly rejected?
Senator, I believe that parties should comply with court orders. I believe that if they believe there's a basis to not do that, they should seek relief. So yes, I believe that court orders should be followed. And what I'm trying to say is I think there are extremely narrow circumstances where there may be a basis to say that there is a legal basis not to follow the order. It's extremely rare. I've never seen it. I've never counseled a party for whom I'm representing to take that position. And it would be my position, if confirmed, that it'd be my expectation that all parties, regardless of who they represent, comply with any orders that I issue.
Mr. Meredith, then I have one more question. Could you just quickly answer that one about Roberts?
Sure, Senator. I agree with the testimony of other witnesses who have appeared before this committee in recent months, like Judge Whitney Hermendorfer, Solicitor General John Sauer, Professor Kate Shaw, all of whom I understand to have said the general rule is that a party before a court must obey the court's order. However, there are potentially certain narrow exceptions to that.
Okay, so just last thing, we were talking about the Kentucky law and your role, and given the fact that you didn't look at this as an enormous burden for these women to go 150 miles and to go to another state, what would you say to litigants who question that you can be even-handed in applying the law, including women trying to vindicate their rights?
Senator, what I'll say to that is that I will be fair-minded and even-handed with all litigants in my court, should I be fortunate enough to be concerned. And I think you can look at the fact that attorneys from all across the political spectrum and are supporting me, co-counsel, opposing counsel, people with all different viewpoints, and that's because they know that I understand the difference between being an advocate and being a judge. When I was an executive branch lawyer, it was my obligation to represent the Commonwealth and defend the Commonwealth's laws. But as a judge, it'll be my obligation to set aside all other personal beliefs, policy preferences, things of that nature, and just simply follow the law.
Thank you.
Mr. Chairman, may I have permission to enter into the record 2 Article